Vercammen, and I'm here to try to give you some information on wills, estate planning, probate, estate tax, powers of attorney, etc. So we usually talk about, people often ask us like, well, why do I need to have a will? Like, doesn't everything automatically go to my spouse? Doesn't automatically go to my kids? Well, nothing is ever automatic. And the whole idea of doing planning is to make things go easier as possible. No one decides on a Friday afternoon, hey, by the way, I think I'm going to go on a 2-week vacation tomorrow, and let me start planning where I'm going. But the most important thing is sometimes someone will say, well, what happens if I don't have a will? Well, if you don't have a will, or the will is declared invalid because it was not properly prepared, or wasn't signed right, or otherwise isn't admissible to probate, number one, the procedure to distribute assets becomes much more complicated. So if there's children, it requires all of the children to select someone in the family to be the administrator. Then all the children have to sign a renunciation affidavit in front of a notary and have that filed in front of the surrogate's office. And sometimes you get, one of the kids that's the troublemaker goes, no, I'm not going to sign it. Not because they want to do the job, but because they're just not cooperative. Well, if all the children don't sign this renunciation affidavit, then a complaint order show cause has to be filed in the Superior Court. Think of automatically having to spend $3,000 or more to have someone appointed as the administrator. Certainly the cost of doing a basic will is substantially less than $3,000. Number two, if there's no will, or the will is not admitted to probate because it wasn't properly done, then let's say there's additional other expenses. So the person who becomes the administrator has to take out a surety bond. There's other additional costs and legal fees. Number three, if you don't have the will, state law determines who gets assets, not you. So remember, it's your decision on who you want to be getting assets down the road. And we're going to go into during the program, more and more people say, you know what, rather than having my monies go to my kids, I'd rather have it go to my grandkids. Or I like to go to my grandkids who are, who acknowledge that when I send them gifts, or acknowledge me, rather than the ones that are just waiting for someone to pass. Number four, we usually advise if there's no will and someone has minor kids, a stranger, in most counties, it's a bald white guy who determines who gets custody of minor children. And, by not preparing, you lose the opportunity to sometimes reduce taxes but the most important reason is when the family is grieving and dealing with death, you don't want to have one more thing to cause fights, aggravation, and other problems like in the family, because I see, all the time. Let's say when there's no will, someone says, "Oh, I want to do it." No, I want to do it. So think, if you don't have the documents, who do you want to get your assets? Who don't you want to get your assets? Let's say, when the family is mourning, they shouldn't be overwhelmed with financial concerns and estate issues where there was no will or wasn't properly signed. Now, I always say, beware of these like free or cheap things online, because oftentimes where it says good in every state, well, there's a difference sometimes between being valid and what is best for someone. So one of the reasons why you hire professionals is so they'll do it right. No one tries to do their own electrical work anymore. No one tries to do their own plumbing work unless they really know what they're doing. So it's best to have a professional do it right. And also make sure that you have something called a self-proving will, so that the family doesn't have to locate witnesses down the road. But we'll get more into that during the program. What has happened in the past year and a half? Well, number one, New Jersey did away with the New Jersey estate tax. So, we used to set up these, these different kinds of inter vivos trusts or things, because New Jersey estate tax used to start on assets over 675. Now, New Jersey has no estate tax. At least we'll see what Murphy does next year. Now, there is a federal estate tax, but that starts at $11.5 million. And not too many of my friends who are in Woodbridge and the surrounding areas have more than $11.5 million. See, so the other thing that's happened is this COVID germ thing. Well, but in a way, we made estate planning easier for people. Prior to this year, we used to mail out a questionnaire, and then the person would, fill it out, and we would sit down and we'd have to go over everything in the office, and then, then we'd try to read the person's handwriting and try to do the documents from handwritten, things people wrote. Well, now instead, again, we make it easier for people. We email out a Word document and a text document so people can fill in the blanks. And, the whole idea is you want to make it as easy as possible for people to get it done, because many people have been putting off. So someone types it up, they email it back to us, we prepare the documents, we email them the documents, people print out the documents. And, when the state was closed, we told everyone, hey, you can go to the UPS store, because the UPS store is allowed to be open while other businesses aren't. You just have to bring 2 witnesses. So again, it made it, rather than putting things off, it was one of the things that we can do without, physically, seeing or touching people. So what does someone have to provide to the attorney? Well, we email a questionnaire. It's, our questionnaire went from 12 pages to basically 3.5 pages, because we don't need to know substantial details about people's assets, because unless there's more than $11 million, it really doesn't matter. And sometimes people also said, you didn't list my assets in the will. I goes, well, I can only list your assets in the will if I know the day you're going to pass and what you're going to own. So you're going to put down your name, your address. We typically recommend and explain why someone should have a power of attorney in a living will. Then you're going to pick someone to be an executor. Now, when there's a will, the person who is the captain of the ship is called the executor. When there's no will, that person is called an administrator. So there's so in your questionnaire, you're going to put down who's executor 1, who's executor number 2, and you never want to have joint executors. That creates twice as much work. So there's, again, an executor 1 and executor 2. There's a reason why there's only one president at a time and not 2 presidents. And there's only one steering wheel. And we've had situations where they were making joint executors creates twice as much work. Even if they were twins living together, it means that 2 people have to go to the surrogate's office or fill out the papers for the surrogate. 2 people have to sign the contract with the realtor to list the house. 2 people have to sign the contract for sale. 2 people have to sign the addendum. 2 people have to go to a closing. So you want to make things as easy as possible for the family. And sometimes we've had situations where there were joint executors and they couldn't agree upon what color the sky was. Brother number 1 says the sky is blue. The other brother says you're stupid. You've always been stupid. Now, we do ask, and it's a good idea at some point, not for the attorney, but you want to prepare a list of what your assets are. But we simply ask, what real estate do you have? And do you have real estate in any other states? Ballpark amount of stock, etc. We don't need account numbers. You do in probate, but not for the purpose of the will. And then, are there any direct beneficiaries? Now, if there's real estate in any other state, then once after the will is probated in New Jersey, you have to do something called ancillary probate to deal with that real estate in the other state. Now, I mentioned what is important though is that for your assets, you determine are you the only person who owns it, or are they owned by you and someone else, or going to someone else directly. So there's certain if the asset has a beneficiary, it passes outside the will. So what are some assets that pass outside the will? Well, for the biggest example is a house that's owned a husband and wife. If it's owned a husband and wife, it's called tenants by the entirety. Automatically goes to surviving spouse. Doesn't need to have a new deed done. There doesn't need to be any kind of nothing done afterwards. Automatically goes to the spouse. Certain things, bank accounts, if it's payable upon death, joint account, joint tenancy, automatically goes to the whoever you put down. So that's why I tell people, if the will can't change that. Whatever you have there, certain assets pass by contract. So think of IRA, 401k, life insurance, annuity. If there's any kind of pension issue where there's a beneficiary, those automatically go to whoever you listed. A will cannot change that. So, and there, we've been involved with estates where, little old lady has all these, they used to buy all these CDs, and the lady put down all these different people on as a beneficiary. However, her will said she wanted everything to go to the niece because the niece was the one that helped her out and took care of her. Well, unfortunately, when she passed, there was very little that didn't pass directly to these other people. So you want to list, want to make sure that it's clear. If there's these other accounts, those people get it outright, otherwise take them off. So then your attorney is going to need to know the balance of your estate, who gets it. And more people are not leaving assets outright to their kids or to their spouse. Why? Well, sometimes, the kids are already well off. They want to put the money for their grandkids, to pay for college, to pay for weddings, to, help the grandkid buy their first condo. So in second marriage situations, we got to be very careful, because sometimes they'll say, okay, the plan is that everything's going to my spouse, and afterwards it's going to divide amongst our two families. And I said, okay, well, that's good in theory, but you understand that if it's going to your spouse, then after you pass, they can get remarried and it goes to their new spouse. And whenever I bring that up, someone says, oh, I'm never going to get remarried. And I goes, well, you weren't planning on getting married a second time, but it happened. So it's important that before you discuss the matter with the attorney, you kind of want to write down, you type up is better, so we don't have to figure out someone's handwriting, who's getting the bulk of your assets. Now, in addition, some people have what's called a specific bequest. What's a specific bequest? Well, a specific bequest is where you're leaving specific assets to, a person or a charity. So someone might say, okay, I'm leaving $5,000 to St. Thomas Aquinas High School, our boys track team. Someone may say, I'm leaving $10,000 to my temple in memory of my mom. Sometimes the ladies will put, I want my jewelry to go to my daughter or my granddaughter, because they know that if it's going to be going to, if the son is the executor, he's going to take the jewelry to cash for gold and say, what do you give me for this junk? Sometimes the men have a specific request that says, I want my firearms to go to this nephew or this person that has a firearms purchaser, because they loved hunting and they were sportsmen. People oftentimes, well, not often, but have what we call the reverse specific bequest. And that means nothing to whomever. That's it. We don't put a reason. We don't give them $1. It's just nothing to this person. And this is why when we sign, if we're the person signing, we're very careful that if it's not an equal sharing, the witness should not be someone that's getting more than the others. As a witness, they shouldn't even be in the room. If there are kids that are, let's say, even under the age of 25 or under 30, sometimes people will say, hey, I want a clause to protect some money from them. So we have, we call it trust within the will, where the money's held by the executor, but the kids or the grandkids don't get money until they're, they could be, sometimes it's broken down 22, 25, and 30, but the money can be used for support, maintenance, for college expenses, grad school. But that's in the executor trustee's discretion. So, someone graduates, college, they're getting a job in another state. Hey, I'd like to buy a condo. Well, Uncle Joe, who's the executor, can say, okay, that makes sense. We'll advance you the money. On the other hand, the kid's 20 years old and goes, you know what? I need to find myself. College is very stressful, and I want to take a trip across Europe with my buddies, and I need, $70,000. The executor says, well, you better work harder at your part-time job because we're not taking your parents' money so you can go and blow it goofing around on trips. So the idea is that even though the age of majority is 18, we don't want 19-year-olds getting money. 19-year-olds don't do anything smart with money. Say, yeah, they buy a fast red car, they go to Seaside and they buy beer. And the other reason is that part of doing the planning is so we're protecting them from the other, from whoever they're dating at the time. Because a guy who inherits a bunch of money, all of a sudden the girl comes by and says, oh, I love you, buy me jewelry, buy me this, buy me that. And, everyone's susceptible. And we right now we see more where older people that are lonely and they get contacted online by someone from the foreign country that suddenly says that they love them because they want to marry them and get their assets. So part of our job as attorneys is to think for the future and to try to protect everyone from others and try to make it go as smooth as possible. So now if there's minor children, there's a clause within the will that says, who would be the guardian? The guardian's what holds the kids, and it's for some parents, it's a difficult decision, but I goes, no, it's not difficult at all. Let's see. I said, if you couldn't watch your kids for the next 2 weeks, who don't you want to be the guardian? And who would be the better person? There's no best person to raise kids, your own kids, but you don't want a stranger deciding, because the person you don't want would have without a will has a right to go forward. Now, sometimes people cheap out and they try to get cheap stuff online or free stuff. And Zig Ziglar was a famous motivational speaker, and he said, cheap is never good. Good is never cheap. And at the best, fudge shop in Wildwood, there's not a sign that says we got cheap fudge. It says we got the best fudge. And if you have a choice of going to a restaurant with a spouse on the weekend, you don't look at the one that advertises we're cheap. You want if you're trying to, or even a date, you want someone. So it's important to have a professional do it right, because also you want to make sure it's what's called a self-proving will. Now, what's a self-proving will? Under the old law, the person signs, then 2 witnesses sign. But then the executor had to locate one of the 2 witnesses to sign paperwork to say, yeah, I was the witness, I was there in the room, and this is I was there. Well, the problem was sometimes you couldn't locate the witnesses, or the witness would say, yeah, I'll sign the paperwork. My fee's $500. And so we'll say, $500? We're not paying you $500. Well, the witness would be able to extort the money. He goes, well, get the other witness. Well, that person's dead. So the law was changed to make it for what's called a self-proving will. And so it requires the person signs, 2 witnesses sign, the attorney and notary signs. Then there's another section, the self-proving section. Person signs again, the attorney and the 2 witnesses sign again. So therefore, basically everyone's signing twice, but it needs the special language. Otherwise, you got to find the people. So by having that, it's saving the family money. And these cheap things online are not self-proving wills. Also, in New Jersey, there's a law that says a bond has to be taken out by the executor unless there's a clause in the will that says no bond is required. So what is this bond thing? Well, basically, it's a clause that says, I'm not requiring that the executor take out an insurance policy on themselves. So, most people says, well, I think I trust my spouse. I trust my kids. So the whole idea is, trying to make things as smooth as possible, trying to make things as easy as possible, for the family. I'd say no. Sometimes people says, listen, I don't have any kids. I don't have any close relatives. Hey, that's easy. Just make up a list of either friends or charities you want to get stuff, and we'll prepare. But we found, typing everything up, makes it easier. And this way there's no spelling errors. And, so what happens nowadays is the attorney will, prepare the documents, email them out. We tell everyone, print them out. And then if everything is fine, we provide language and instructions on how to sign in front of a notary at the UPS store, because the UPS store, again, was open during the COVID. You have two witnesses. Don't use a family member if there's unequal distribution, but if it's I call it the typical, family where everything, it's either going to spouse or everything's going to kids. Yeah, a kid can be the witness. Now, what is important is make sure that only the original will can be admitted to probate. Only the original will. So think of probate. It gets admitted to the surrogate. We like to think of a surrogate as a fancy name for the will clerk. And probate in New Jersey is the easiest state in the country. Can you believe that? It's the easiest anywhere. So to probate the will, the surrogate needs the original will, death certificate, check for $150 or so, and a form filled out. Before COVID, someone could be in my office at 11:30, and I'd say, okay, go over to New Brunswick right now and come back in 20 minutes, and they'd have you in and out. Because all the surrogates' offices are closed to humans, we have to fill out a surrogate information sheet ahead of time. But again, we type it up, we email it to the surrogate's office, we'll fax them a copy of the will, fax them a copy of the death certificate, they emails papers back. We then have the client sign, send in the original will by certified mail with the original death certificate. Surrogate sends us the papers back. I mean, they're working remote, but they're doing the best they can under the circumstances. But again, New Jersey is a probate easy state. What are some of the clauses that typically go into a will? Well, number one, debts and taxes be paid first. Two, distribution to spouse, or sometimes a trust for a spouse. Why would we have a trust for the spouse? Well, sometimes it's for Medicaid and asset protection. So it's much more common in second marriage situations. But someone says, okay, a chunk of my money is going to my spouse, but it's going to go into a trust for them, not outright. Therefore, they're able to get 5% or $5,000 per year, and automatically. Plus, the trustee can expend as much money as they deem appropriate. However, the rest of that money is protected from Medicaid. Even if the person died the year before, it's protected from creditors. What kind of creditors could be having? Well, sometimes people get crazy and sign up for, big credit cards. They sign up for, reverse mortgages. Sometimes people get gambling issues. So we set up trusts within the will. Then there's a clause that says money's to children, but sometimes for the same reason, we don't give money outright to children. Not because we love them, but some kids have substance abuse issues, gambling problems. My clients that have, kids that, were special ed classified, they know the importance of setting up special needs trusts, within the will or otherwise, so that the kids don't lose entitlements. But it's difficult for some parents to face the fact that, if they leave a chunk of money to one of their adult kids, their kid's going to spend it. So sometimes they'll want within the will what's called a testamentary trust. It's not a standalone trust. It's not funded unless someone passes away. But the good thing with that is those monies will be held to help support that. And we were involved with a probate matter that it was such a good idea by this mom, because the son had an alcohol problem, he had other issues, he owed everyone money under the sun, and the trustee was one of the other kids that could make sure that used the money to pay his rent, give him gift cards from ShopRite to pay for food, pay his cell phone bill. But then there was a challenge by creditors and the guy's ex-wife for alimony, and they wanted to invade the trust. And the judge agreed with me, because we said, Judge, the reason why we do this is to, protect the money. Because, hey, if you give an alcoholic $100, they'll buy $100 worth of booze. If you give them $1,000, they'll buy $100 worth of booze and then give away the rest or just blow the rest. So the idea is trying to protect people, just like having, trust for the minor kids. There's a clause that says who's going to be executor, who's going to be the trustee, usually the same person. You want to make sure there's a clause that says no bond is required. You want to have it a self-proving will. And I mentioned earlier, some people have specific bequests. I mean, I put in mine, I wanted like chunks of money to go to my grammar school track team, my high school cross country team, my college cross country team, and my law. It wasn't a big chunk. I'm not really taking away from my family, but it's just something that made me feel good, and more and more people are doing that now. Okay, so we went over certain things in the wills. The next thing we're going to discuss is the power of attorney. Now, a will takes care of your assets if you pass away. What is the power of attorney? Well, the power of attorney is a document while you're alive. You're giving the ability to a family member, a trusted person, to make sure that your bills are paid and to act on your behalf. So the typical power of attorney is either effective right away or only upon disability. If it is effective right away, that's called a durable power of attorney. That means it's effective right away and it stays durable even if someone becomes incapacitated. One that becomes effective only upon disability and with a written certification by a doctor is called a springing power of attorney. And not that many people pick that one. But we had a client last year, and I'm explaining this to him. He goes, Kenny, he goes, hold on. He goes, I'm a carpenter. I don't understand springing in legal terms. Explain to me in carpenter terms the difference. I goes, okay. If it's effective right away, your son can steal all your money right away. If it's effective only upon disability, your son has to get a note from a doctor before he can steal all your money. Do you trust your son? And then the man said, I trust my son with my life. He goes, well, then make it effective right away. Because the problem is, if it's not effective right away and it's only effective upon disability, you could have a note from a doctor, certification from a doctor, but good luck in going to this, Morgan Stanley or some bank with the power of attorney that says effective only upon disability with a note from a doctor. They might say, well, how do we know that's any good? So it's better to be effective right away. However, if you're writing stuff down, here's a tip. Don't use cheap forms online because the banks find ways not to honor them. A lot of banks were giving people a hard time and they weren't honoring perfectly good powers of attorney, properly notarized by, or executed by the attorney. So New Jersey legislature came up with a law. And the law said, hey, if the bank does business in New Jersey and it makes reference to the New Jersey statute, then the bank has to honor it. However, it has to make reference to the particular section 2 of PL 1991 C 95:46:2B-11, et cetera, et cetera. And I'm pretty sure these cheap things you find online will not have that. So again, for the power of attorney, most people make it effective right away rather than effective only upon disability. And the important thing on having a power of attorney, I think in a way a power of attorney is more important than the will. Hey, if someone doesn't have a will, they're married. Hey, yeah, it does automatically go to the spouse if it's first marriage and the kids from the same marriage. If someone doesn't have a spouse, yeah, it automatically goes to their kids. However, let's say sometimes we get calls from someone, oh, I need to get power of attorney over mom, dad, or Uncle Joe. Well, unfortunately, you can't get power of attorney over anyone. They have to affirmatively give it to you. And I try to reach out to everyone who contacts us while I'm driving in the car with the hands-free thing, so I get two hands. But I ask everyone, okay, let's go over this. Where's the person at? Well, they're at the care facility. Okay, are they competent now? If the answer is no, I goes, well, if the person is not competent now, we can't do a document for them. Let's say one of my neighbors in Edison says, Kenny, I need a power of attorney so I can sign for my husband at the closing. We're moving to Carolina. Hey, okay, fine. When can Joe come in? Well, he can't. He had a stroke. Well, is he competent now? No, not really. He goes, well, can't sign the document if he's not competent. And they say, well, how can I transfer it? Well, if he's alive, you'd have to go through the expensive and complicated procedure called a guardianship. And a guardianship is one of the saddest, court proceedings in a way, because you're having your loved one, dad, mom, brother, whoever, they used to call it incompetent. They politically corrected the word now to incapacitated, but it's very sad because you have to go into open court and explain why, the person now needs a guardian. And here's the end part. If you don't have one of these for guardianship, if there's real estate, then you also have to get 2 different appraisals and then get all the parts of the sale approved by the judge in the guardianship. Well, you don't need that with the power of attorney, because in the power of attorney, you want to have a clause that says in the first line, let's say I give you all powers, including real estate, to execute any contracts, deeds, mortgages, bonds, to sell, transfer real estate. Now, if someone's okay, sometimes people want to have what's called a limited power of attorney. A limited power of attorney is to authorize someone that they trust to go to the closing and do all the transfers needed for the real estate. Some people are snowbirds and they're in Florida soon, right after Christmas time, or when it starts getting cold, and they're giving power to someone to do it. Now, if a power of attorney is being used to sell real estate, the power of attorney has to be filed with the county clerk's office. Yeah, but other than that, do not let the original power of attorney out of your hands, because once a person is no longer competent. So now, how long is a will good for? Well, a will is good as long as it's done properly. A will is good forever. I do tell people, take it out, make sure you have the original. And, and also, okay, people also ask, where should I put the original? Hey, buy a fireproof box, put it under your bed. Don't put any gold or jewelry there, just papers, and make sure it's closed, because if there is some kind of fire, oftentimes the bigger damage is not from smoke, it's from water from fire hoses. So make sure the thing is properly closed. Now, on the other, but a will that was done in 1990, as long as the people it contains what you want, it doesn't have to be redone. Sometimes there's an issue. Can the executor still do the job? Our rule of thumb is who should be the executor, who should be your person in the power of attorney. Well, you want to have someone that, again, can do the job. And so, number 1, can they drive to the bank? 2, can they walk up a flight of steps? Because if the person is, blind, disabled, or just can't get around, they should not be the captain of the ship. I'd say we're not anti-old people. We're not anti people that can't get around. It's just being practical. I remember when I had knee reconstruction, knee surgery, and I couldn't drive for a while. At least I had it in case no one could get around. Now, it is a good idea to sign a new power of attorney every 5 years. Why is that? Well, because again, sometimes we're fighting with banks and financial institutions. And if they see a power of attorney that's 13 years old, they're going to say, how do we know this is still good? Also, if the person who's in your power of attorney, if their name has changed or their address has changed, it's a good idea to sign a new one. You know, having a power of attorney prepared by an attorney is only going to cost you maybe $150, $200. Doing a guardianship is going to cost $4,500. You know, so that certainly doesn't save you money having to spend $4,500 going through a guardianship. But again, other thing, you can't find the original documents, well, then get a new one done. Let's say our rule of thumb is if you can't find your documents in 48 hours, well, probably your family who the executors not be able to sign it. So it is we highly recommend that people have the valid will and the valid power of attorney. And now a photocopy of a power of attorney cannot be admitted to probate. I mentioned the surrogate is like the fancy name for the will clerk. You must have the original. If you don't have the original will, then you've got to go through this lengthy court proceeding, because there's a presumption if you can't find the original will, it was destroyed. So power of attorney, though, most institutions will accept a copy as long as you can show them the original without giving it to them. I have been recommending that after the power of attorney is signed, that the clients have the document scanned and then emailed to themselves, to the person who is like agent 1, agent 2. And it's also a good idea to email the scanned power of attorney to your financial planner, your banker, anyone where it would come up in the future, because it's much better if they have it in their record as, this kid or that kid would be able to help out mom, dad, Uncle Bill if needed, as opposed to all of a suddenly, the kid calls the financial planners, oh, I need to liquidate some of dad's assets. He had a medical procedure, and the financial planners going to say, who are you? So it's a good idea to do it ahead of time. And it's the people sometimes would say, well, shouldn't I get a trust? I heard that you should get a trust done. I heard you should get a trust done. I heard you should get a trust done. I go, and my mother-in-law used to ask me every other year, I want to come in and get a trust done. And I would say, why? Were you watching Susie Orman? And she would say, oh, yes. And I goes, I love Susie Orman. I goes, listen, Susie Orman is so correct if you live in probate difficult states such as New York, Florida, California. Susie Orman's in New York. So if you're in New York, you should have a trust on, put your assets into a trust. You move to Florida, put your assets into a trust. The mechanism out there is a project. But New Jersey, again, it doesn't take more than a week to get the papers from the surrogate, maybe 10 days after COVID. It costs you $150. I ask people, why do you need a $3,000, $4,000, $5,000 trust when a $500 will do you just as good? Now, again, probate in New Jersey is inexpensive. Now, there's two kinds of trust. One is a revocable trust. Sometimes they call it living trust. And the other is an irrevocable trust. A revocable trust in New Jersey is really garbage, and it's only prepared by trust salesmen. They sometimes say, "Oh, you don't want your will being like it's a public record." Well, unless someone's leaving their money to the Ku Klux Klan or someone, what do you care about that? People know that your kids are getting your assets. But one of the positives of an irrevocable trust is if you put your assets in, it's not just doing the document, it's having the trust now own the house, own the assets. If 5 years go by, it's protected from Medicaid. A living trust doesn't do that. Probably the only positive of the living trust was that during COVID in the spring of 2020, if someone passed away, the trustee could act right away and they didn't have to wait a week or so to start doing stuff. But again, I always ask people, why do you think you need to have a trust done? Knowing because probate in New Jersey is not complicated. Florida, California, it is very complicated. So, and if someone says, I insist upon having a trust, okay, great, but I'm a straight shooter. I don't believe in selling someone something that is not needed or is not in their best interest. The last document that I want to address is the Living Will Advance Directive. Now, everyone's heard of the Karen Ann Quinlan case and the Terry Schiavo case, where someone is in the hospital, and these cases took place. Well, the Karen Ann Quinlan case was the first decision in the United States which recognizes the family's right to end certain life support, but it needed a court order to do it. New Jersey then adopted the Living Will statute, where someone who's a competent adult can make decisions ahead of time. And again, it's a good idea to have the living will, because the living will really isn't for you; it's for your family. So that if there's a catastrophe or a horrible bad illness, so that there is no you've written out ahead of time what you want. Because I remember one time a person who did not have a living will, the doctor says to me, okay, should today be the day? And, you say, geez, I feel bad having to make that decision. I mean, you know what the right decision is for someone who's 92 years old that's never going to open up their eyes and never walk the planet again. But you really hate to be the one to say, yeah, let's end that person's life today. I couldn't do it for my dog. So the whole idea of doing this Living Will Advance Directive is making the decisions ahead of time so your family doesn't have to be put on the spot. So in the Living Will Advance Directive, the first section, what you do is, and we copied part of the language from the the New Jersey State Medical Society. This way doctors are familiar with it, and there's no question as to whose language is what. Made it easy. So the first section deals with fluids and nutrition. So basically with fluids and nutrition to be withheld or provided. So probably 85% of the people now say, hey, if there's no hope for me, I'd say let's no fluids, no feeding tubes. Now, it's not where someone has a sudden heart attack where they say, we're not going to do anything. As long as you can talk, you can be you can tell the doctors, what you want, but it's more if you can't talk for yourself, you've taken the pressure off the family. The next section deals with, medical treatment. We call it artificial means, other kinds of tubes. And 99% of people say, hey, listen, if there's no hope for me, I don't want to be kept alive as a vegetable where I'm just lying in the bed and, and having my family have to suffer and see me, unconscious in a hospital bed, in a nursing home bed. And it was kind of funny, years ago when I was first married, you're all lovey-dovey when you're first married. And my wife said, oh, if something happened to you, we couldn't, I could never let them stop life support. It was okay, fine. I'll just keep my dad because he's logical like Mr. Spock. All right. So then 25 years go into the future, and my wife goes, so wait a minute. You're telling me if you pass away, I get $750,000 in life insurance tax-free and I can stop working? So again, you want to make sure that the Living Will Advance Directive, you're picking someone that has the ability to make some medical decisions for you, also to have the ability to talk to doctors. So we put in our power a Living Will Advance Directive is a HIPAA authorization under the federal HIPAA law that authorizes doctors to speak to, that family member. But it's also, so there's a number one and number two, not joint, but it's, similarly, you want to have someone as the captain of ship, because what we found is that sometimes all of a sudden it's at the end and one of the kids who wasn't involved with helping out, wasn't involved with making sure that there was food at mom or dad's house or helping them pay the bill, wasn't involved. All of a sudden they come barging into the room and they goes, "I'm in charge now. I'm in charge." He goes, "Well, technically, no, you're not in charge. It's whoever the person put in their living will advance directive." But part of planning is you want to get the documents done, and that way, things are good. I'm going to put, by the way, like if I have some materials, and if anyone emails me at our email vercammenlaw@nglaws.com, I will email them some of the materials. I mean, I loved when we did the programs at the libraries, but because of COVID. So vercammenlaw@njlaws.com. Also, typically we charge $200 to do a probate consult, whether or not it's, on the phone, by Zoom, or in person, but we don't charge the consult fee if anyone was on any of our programs. Okay, so we've covered power of attorney, we've covered wills, we've covered living wills. Before I bring in our financial advisor to talk a little bit more about this, I want to just go over in a nutshell how easy probate is in New Jersey, where there's a will and not people fighting. Okay, the will is admitted to probate by the surrogate. Then we send out a notice of probate to the different beneficiaries, and we send out a notice of probate of when the will is admitted to probate to the people that were excluded in the will or who would have been inherited if there was no will. That way, after that, it limits the time period where they can challenge the will. Now, when we sign it, typically it is important that we make sure that someone is competent to do things. So, if I can talk to someone and they filled out the form, that's pretty good. Sometimes people are ill. Well, last week I was at an assisted living signing for a gentleman I've known for years. Another night last week, I went to update a living will for a fellow and watched him sign because he's homebound, and it doesn't make sense for him, his wife, who's in assisted living, to be his power of attorney person. So therefore, when we do stuff right, we're preventing challenges down the road. Okay, so other things the executor to do, if there's different beneficiaries, getting a tax ID number, setting up an estate account, contacting all the different places where there's money, liquidating assets, selling the house. Oh, by the way, the attorney then has to file the notice of probate with the county surrogate's office. Beginning of each year, the accountant will file the last federal tax return, the last estates. The executor pays the bills, make sure everything is paid. And then now New Jersey still has a thing called the inheritance tax. However, the inheritance tax, there's no tax if it's going to children, stepchildren, spouse, grandchildren. If it's going to brothers or sisters, the first $15,000 is tax-free. After that, there's a tax 11%. It's going to charities, no tax. And but have to be bona fide charities, not GoFundMe. But any other human being, it's taxed at 11%. Once the executor's done everything, then the executor typically types up what's called an informal accounting. The attorney prepares what's called a release and refunding bond. All the beneficiaries got to sign in front of a notary, and then we file that with the surrogate. If there's no will, if there is a will, we don't have to file it. Child support judgment should be obtained, and child support got to be paid. Let's say that one of the kids doesn't sign the release and funding bond. Well, that means that no one gets their money, and we have to go through a formal court accounting. So what we typically do in those cases where someone is, hasn't signed, we send a letter to all the beneficiaries saying, we got the release and refunding bond from everyone and we're ready to distribute. However, we did not get the release and refunding bond from, say, brother Fred in Colorado. That means no one can get their money. Okay, so the whole idea is to make it as easy as possible. Now I'm gonna jump upon a couple quick questions. So if there's minor kids, you want to have a will and pick someone who will be the executor and guardian. And if someone's divorced, like the last person on the planet you want as the trustee is the ex, because how do you know that they're going to, take care of the kid and not share it with someone else? If someone has a disability, some people set up special needs trusts. I've mentioned in New Jersey, aside from expensive trusts to shield assets from Medicaid, there's not usually, most people don't need to have a trust in New Jersey. If there's a death certificate outside New Jersey, well, the surrogate's office, I guess, handled that where people have died outside of New Jersey. It really depends. You can only have one domicile, so the primary place that it's administered where their domicile is. I'd say there's no such thing typically as a joint trust. Each person has a trust. And I'd say I mentioned we were going to email down the road. I'd say information if someone sends me their email. Okay, so with that, I'd like to introduce a financial planner, Dave Solenko. And Dave, if you're ready, it's time for you to start talking about some of the financial planning issues that you've seen people make over the years. Dave, you ready to go?
I am ready to go. Yes, I am here. Let me up. My video needs to be. I guess the host needs to put me. But I'll start now since we're pretty deep into this, and I don't want to hold everybody up this late on a Monday evening. So good evening, everybody. My name is Dave Solenko. I am part of a group called GWN Securities. I will bring up a name that few of you may have spoken to in the past who happens to be a partner of mine. His name's Bill O'Brien. He was through the library system for some of you, talking about the 403B with MetLife, and he and I are partners. So if you do know of him and you're still working with him, you get me as part of the package potentially. Should a later date you call me, I trust Bill with my life when it comes to this business. So for those of you who know Bill O'Brien, I hope you look at him fondly. And I'm going to now start with how I look at certain things here when it comes to, people call it, whether it's planning mistakes or whether it's just food for thought, really. A bulk of this from the beginning starts with people who are really in pre-retirement or retired, but then we get to others where it deals with people who are well into the workforce or just starting in the workforce. So let me get through this relatively quickly, and I'll put my contact information in the chat box at the end myself. So number one, one thing I find more than anything else, especially with people who are close to retirement or in retirement, are holding on to risky assets for too long. Now, I know some of you may say, well, bonds right now are not really returning much, and that is true. I'm not telling you to get rid of all of your stocks. It's just if you're a stock person or if you have an advisor who has you in mutual funds, it's important to really understand how much you want to have in the market at this point. And really it's, far too often I find that, people, because I like to say CNBC may be one of the worst things that possibly could have happened 25 or 30 years ago, not from the information per se, but I think it emboldened people to become semi-experts or experts enough to be dangerous. And they'll tell their neighbors, and the neighbors will tell them, or my brother will tell me about a stock, or I even get people who are in their 70s now calling me, Moderna just obviously came out with very positive news about the vaccine, a 94% hit rate. and she's calling me, oh, I want to buy the stock, I want to buy the stock. I mean, does it really make sense at this point where it's gone up a lot? I don't know at this point. But it's important to be very, very careful when owning stocks as to which stocks do you have? Because again, we're not making income that much on bonds, and maybe it's stocks that create dividends for you, whether it's household product stocks, Procter and Gamble type stocks, or things of that nature. And it's, it behooves you to speak with and put the feet to the fire of your advisor if you have a financial advisor. I mentioned Bill O'Brien before, and Bill and I have made a commitment when we know clients of ours are within 3 years of retirement, we really have to start having that conversation instead of waiting till it's too late like it was in 2001 or 2008 or maybe potentially earlier this year when we saw in February and March. So it's important to be very careful about stocks and which ones that you own and not being too aggressive. Number two, very important, I think for everybody, is to understand and to have a cash flow or expense worksheet, whether you do it yourself or if your advisor has a sheet that they can give to you that you can write in pencil, because obviously our cash flow and our expenses change over time. So you need to create a budget. You need to know whether you're early in your career, whether you're in the middle of the career, you have children. I have one in college. I have one about to go to college. And also, obviously, headed toward retirement and in retirement, because a couple things I'm about to mention in retirement, very important, is healthcare. You need to understand what are the costs for me in healthcare. We all want to be very healthy, and we want to be able to hopefully travel, hopefully down the road here soon, we'll be able to travel. And, it's great. We want to go see the grandkids, whatever we might want to do, spend a lot of time together. But obviously, the older we get, many people fall into healthcare issues. So it's important to know what your expenses are and potentially will be going into the future. Another thing is, for those of you who are getting close to age 65 or getting close to retirement, if you're still on a healthcare plan and you're working beyond 65, is to make sure that you file for Medicare on time. If you're retired and you wait till 66 to file or later, there will be a potential for a penalty by filing too late. So it's important for you to understand that you need to file on time at 65 for Medicare, or if you're working the moment you retire after whatever later age that might be, to make sure you apply and file for Medicare. I just mentioned about healthcare costs in retirement. And we talk about Medicare and paying for Medicare Parts B and D, and then paying for the supplement to take care of other expenses. So it's vitally important, again, knowing what your expenses are, knowing you need Medicare, knowing what the expenses are for paying for Medicare based on your retirement income in those particular years. Another question a lot of people have is, when do I start Social Security? You have the ability to take Social Security at the age of 62. However, understanding that between the ages of 62 and 70, for every year you don't take Social Security, the amount of your money coming to you on a monthly basis goes up by 8%. Once you start taking at whatever age it is, 62, 66, 67, 70, now you've locked in that income. Now, for some people, they need the income. They need at age 62 to be able to take income, and God bless, take your money, you've put it in there. However, for some of you where you have if some of you have pensions, if some of you have other income sources, if you're going to work later, a part-time job, it may not make sense to start taking the money. You want to start then looking at things such as your health, what your health has been up to this point, and also your family history of health. If you have a family and parents or grandparents lived into their 90s, and you've been healthy all the way up to through age 60 plus, you might want to consider to wait for a later date to start taking your Social Security. But again, that's up to you to talk to a financial professional and your accountant for sure. One other thing is when a husband and wife, there are times when, let's say, the first spouse is retired, they're older, they're the larger breadwinner, and the one who's not making as much money now turns 62. Well, do I really want to start taking money even, it's early? Well, okay, that's fine. You may not want to, but on the flip side is if your spouse, your older spouse who has a larger Social Security amount coming in is taking, you might want to take in the Social Security at that point also, because if your older spouse passes before you do, you will then step up into the amount that they're getting. You're not going to get both when he or she passes, but you'll jump into the higher amount at that point. The sixth thing I want to talk about are called required minimum distributions. Up to the past year or two, you had to start taking distributions from your 401k, your IRA, your 403b at the age of 70 and a half. Now it's been moved to the age of 72. Just because we have been deferring all the taxes for all these years, well, the government wants its money at some point, and they're requiring us to take those assets, a portion of those assets. At age 72, it's just under 4% in the first year, and then it goes a little bit higher each year. It's not like they're asking you to take a lot. You can take more if you want to, but you can't take less. And if you fail to take your minimum distribution, whatever portion of that minimum distribution you don't take, you're liable for 50% penalty on the amount that you don't take, which is a very, very large sum. Not for a lot of people, but this goes for a handful of people. Will you actually need your 401k, your IRA, your 403b in retirement? There's some people who say, you know what, I have income coming in from elsewhere. I really don't need these assets. You could consider converting those assets into a Roth IRA, which is the after-tax IRA. If you put money into the after-tax function, any growth on that, if you take money from that later on, is not taxable to you. But a lot of times the reason to do this is you're going to pass this asset on to a beneficiary, a child, a grandchild, and they won't be taxed on that money either if you convert to a Roth. Big issue, and unfortunately many of us have seen this happen. The question is, are you financially equipped to handle the cost of care for home care, assisted living, long-term care? That's a really, really big issue, because understanding, I'll say right off the bat, if you need to go into a long-term care facility in New Jersey, you could be seeing an annual bill of $100,000 a year. Some people in years past, well, they don't have enough money, or they decide to give all their assets away to another person, a child or whatever, and then they become indigent. You can qualify for Medicaid. The problem is you and your family cannot choose the facility you're going into. So it depends on where the facility is, where they have an open bed, and the quality of the place that you have to be put into from a long-term care facility standpoint. And then for those of you who have actually had to care for a parent, a sibling, where these people need care. Now it's not about the money. You've now maybe saved on the money, but for those of you who have gone through this, you understand the mental and emotional strain that goes on for everyone. And is it really in that person, meaning the caregiver's best interest, to give care at home until mom or dad or brother or sister passes away? So there are a lot of questions when it comes to long-term care, the care costs going forward. For people in the workforce, I hope people are saving for retirement. If you are given the opportunity to put money away in a 403B, in a 401k, in an IRA, you really up to you. Now you can maximize these. I mean, you know, it's over $19,000 to maximize for anybody under 50, and up to 26,000 for people 50 and older. They could put that maximum away. Now, a lot of people won't be able to do that, I understand, but you have the opportunity to put that money away for retirement. Now, it's not just helps retirement, but the more money you're able to put away, it also reduces your taxable income when you do your taxes. If you have children, saving mechanisms for college, grad school, whatever it might be. Are you putting money aside in a 529 plan? Or if you're a grandparent, are you willing to give money to an institution to pay? When you give money to a college for the benefit of your child or grandchild, that's not considered a gift. That's it's like a business transaction. So you are more than welcome and allowed to do that. For those of you who are working, are you set up financially if you or your spouse become disabled? You know, for some of you, there is disability insurance through work, or your spouse has disability insurance through work. But for others, there is not that insurance that's available, or what's being given to you or presented to you through work is not enough to cover your utilities, your mortgage, your groceries. So it's important to think about, are you actually financially set, or do you have something set up in case there is a disability? And then my last point here, and I appreciate your patience, is, and this goes for all ages and really ties back into what Ken has talked about with estate planning. You know, when we talk about estate planning, a lot of people are, well, you know, there's no, I don't have estate taxes. What do I need to do a will? Well, it's really more about family planning. And so the question is what is the financial impact of not creating or updating your will, and also not changing beneficiaries on retirement assets, life insurance, and annuities? So first of all, the financial impact on not creating or updating a will, and Ken mentioned a couple of these pieces here. Number one, for a family that have young children, you want to do it at the very least for guardianship. So you know, whomever you are putting in the will, you trust them to raise your child. Now, they may not be good with money, and if there's a trust involved there, you may name a separate person to run that trust so that money is available for the children. Maybe you trust that same person, but you have to have that important conversation with your significant other about the children and who would be best, God forbid, both of you, or if you're single parent, if you're no longer around. Step two is, I mean, my children are 19 and 17. My son's about to turn 18. So they're both the age of majority. They'll be able to, if something happened to my wife and I, they'd be able to get assets. Do I really trust these kids to be able to efficiently use money the rest of their life that we have left for them? No. I think it's important to consider a paragraph within the will that would set up a trust. Which brings me to the next point. Now the children have grown up. They've gotten married. Unfortunately, in the society, the percentages when it comes to divorce are 50% or higher. What happens if you and your spouse pass away, you leave your assets outright to your son and daughter, and one or both of them get divorced? They've already, what the word is called, commingled the assets with their spouse's assets. They're part of a joint account or joint accounts. That now, what I call the future ex-spouse, now they get half, roughly half those assets. So again, that trust that I talk about, that paragraph that's put into the will, is vitally important, so you can make sure that those assets are maintained in trust for the benefit of your family members, not for that potential future ex-spouse. Now we also have many people who have had multiple families. They've been married more than once. What happens in the case of, well, if I pass away, what happens to my surviving spouse and what happens to the children from my prior marriage. And Ken is someone you definitely want to talk to when it comes to setting up these type of trusts that within the will that would help benefit the surviving spouse, but also leave remaining assets for the benefit of the children of the first marriage. And then finally, obviously, the older you get, you just want, if you forget about any assets, the will is all encompassing. So you become elderly, you want to make sure, you want a document that's all encompassing. And the last point I'm going to make is making sure we're changing beneficiaries on retirement assets, life insurance, and annuities. New Jersey has a law that, even if you didn't change your will and you got divorced, it would be recognized through New Jersey that, well, obviously that person is not the spouse anymore and the assets would go where they're supposed to. But when it comes to a 401k, a 403b, a life insurance policy, or an annuity, those are generated specifically by the beneficiaries you write into the documents, into the retirement plan. If you get divorced, but you fail to take your ex-spouse out of any of these documents and you pass away, guess what? The ex-spouse gets it. Even in some worst case scenarios where you name one beneficiary. And Bill and I share a client that the father named the son the beneficiary of a life insurance policy. But didn't name a subsequent beneficiary, just left it for the benefit of the son. Well, the son predeceased the father, and the father never changed the beneficiary on the life insurance. And now the life insurance has to go through the probate process that Ken was talking about, through the estate. Actually, he didn't even have a will. And so there had to be an administrator named, and then there are nieces and nephews coming out of the woodwork trying to control the estate and also getting the benefit of this. So again, this is not to scare anybody, but it's important points that I want you to recognize that are vital, whether you're younger, and obviously a lot of what I spoke about as you're getting toward retirement and through retirement. So what I'm going to do now is I'm just going to pass this along. I'm going to add my contact information on here. Feel free to grab it, but I appreciate your patience. Thank you for letting me speak this evening, and thank you for the invitation to this event. It was a nice turnout.
Thank you so much for jumping in there. We do have a number of questions from the chat. So whenever you're ready, Ken, I'll start reading them off.
Okay. Are they new questions that I didn't cover earlier? Because I tried to touch upon some of those questions there.
I think you might have covered the
yeah,
first one.
because I went down the questions deal with minors. If someone's divorced, don't let the ex-husband have it. And by the way, like more and more, we are doing documents where someone is separated. There's a law that says, okay, if someone gets divorced, the spouse is not automatically getting under the will. But if they're separated and someone passes, like their spouse hasn't. So, someone gets separated, goes, hey, you did a power of attorney a couple years ago. That gives your soon-to-be ex the ability to go in, take all the money out of the account, set up new accounts, take your money out, get new documents, make them not the person who you picked in your will, make them not the person you have in your power of attorney. Okay, question.
I'll say the one from Janet T. She says, how do you handle the death of a U.S. citizen outside the U.S. where the death certificate was issued by the other country and they have assets in the U.S.?
Okay, so I touched upon the issue where someone passes, you can only have one domicile. So let's say someone, passed away in in India, but they have assets in New Jersey. If there's a will, the will is probated in Middlesex County where there was a domicile. If there's no will, the family has to go through an administration in Middlesex County. So they got to pick a county where the person, let's say the person, didn't have a don't, but they had assets, then it'd be the county where they were, where the assets were. Sometimes people also ask me the question, will this will cover my assets in the country, this other country where I have assets? And I say, okay, this is important. Write this down. And they take out a pen and I said, I don't know. I said, I can tell you what the law was 3 years ago, but that is not best for you. So, and assume is always wrong. It's all no, assume is never a good answer. So I typically recommend people is that, listen, if you have assets in that other country, why don't you, like, I can do your will, take care of your assets here, but let's go through the issue of what other assets do you have, and we can at least do documents that cover your New Jersey issue. Does that answer the question?
I hope so.
Yeah.
But yes, I think all the other questions were mostly about beneficiaries, the joint trust versus individual trust, which you went over extensively. And yeah, I think you pretty much covered most of them.
Sometimes I say, hey, if someone has a trust, we make much more money. But I always want to do the right thing. I read a book that it was called Building the $1 Million Estate Planning Practice, but it was really about trying to trick people into spending $5,000-$6,000 on trust packages. And I says, you know what? The way I was brought up, my parents tried to raise me. Would I be comfortable with going to one of my parents' friends and saying, oh, you need this $6,000 trust package when a $500 will or $400 will would be best? Would I be able to sleep at night if I went to my best man and said, oh yeah, you need to have this expensive trust package or this? No. So it's all about, trying to do the right thing for everyone. Okay. Okay. Did that answer the question?
Yeah, and I hope whoever asked that question in the chat got their answer. I think so.
Very
and plus,
good.
We're going to send out, your contact information. You have some brochures that you want to share with everyone in the chat or everyone who's participated tonight. So you guys will get a follow-up email with the brochures, contact information, and a link to view this recording on the Woodbridge Library's YouTube page. So if there was something you missed and you wanted to go back to it, it will be available.
Yeah, I'm trying to, I'm not sure if it's coming up, but I tried to post my information in the chat, but I don't know.
I linked to your website, your
okay.
email address, and your phone number.
Yeah, okay.
But
so
you'll get but I'm going to send out a follow-up email with all of that information.
We're going to use the Vercammen law one, because that way it goes to the office and doesn't go to my cell phone. Okay, thank you, everyone. Have a good evening.
Thank you all for attending tonight.
Thank you very much.
Thank you, David. Nice to meet you too.
Yes, you too. Great turnout. This was wonderful.
Awesome.